Get ready. 3 seconds. 2 seconds. Start. The sole appellant was convicted under Section 302 of the Indian Penal Code for committing murder of her husband and was sentenced to undergo rigorous imprisonment for life and also to pay fine of rupees 5,000 with default clause. The prosecution case in brief is that on 20/07/2014 at about 9 p.m. the informant had informed the officer in charge of the nearby police station over phone that a murder had taken place in the tea estate. On receipt of the information, the officer in charge of the police station had rushed to the tea estate, and on arriving he found that the deceased was lying unconscious inside the house in a pool of blood, and an axe was lying by his side. The injured was then sent to the hospital and the axe was seized by the police. Later on, it transpired that the appellant had killed her husband with an axe. An Ejahar was lodged on 21/07/2014 at the police station by reporting the incident. Based on the Ejahar, PS case number 77/2014 was registered under Section 302 of the IPC against the appellant as the accused person. On completion of investigation by the police, charge sheet was submitted against the appellant. Charge of having committed murder was framed, and since the accused had pleaded not guilty, the case was put up for trial, which has ultimately led to the conviction of the appellant under Section 302 IPC. There is no eyewitness in this case, and the prosecution case is entirely based on circumstantial evidence. The prosecution side has examined as many as 9 witnesses, but no evidence was adduced by the defense. PW8 is the medical officer working in the Department of Forensics Medicine, Assam Medical College, Dibrugarh, who had conducted the postmortem examination on the dead body of the deceased. The postmortem report Exhibit 3 mentions the following injuries on the body of the deceased. 1. Male dead body of average build, dark complexion, dressed in a black long pants and underwear. Body found cold both externally and internally. Rigor mortis, passing off and present partially over lower half of body. Number 2, within bracket 1, chop wound of size 8 into 2 cm into brain deep over left temporal region of scalp. On dissection, fracture of length 6 cm found over left temporal bone underneath. Cut injury seen over membrane within bracket 3 cm length, and temporal lobe of brain within bracket 3 cm. Number 2, chop wound of size 6 into 2 cm into bone deep over left cheek over maxillary area, cutting maxilla as well as top of left pinna. Point number 6, the doctor has opined that the death of the deceased has occurred due to coma following head injuries sustained by him, and that all the injuries were antemortem caused by sharp-cutting heavy weapon and were homicidal in nature. From a careful scrutiny of the medical materials available on record, we are convinced that there was a quarrel which took place between the deceased and the accused immediately before the incident, and therefore it is clear case of provocation caused by the husband, which was grave and sudden and had led to the incident resulting in the death of the deceased. It quite unusual for a wife to kill her husband by assaulting him with an axe, and in the absence of any other motive for committing the crime, we are of the unhesitant opinion that, save and except grave and sudden provocation by the deceased husband, there was no proximate reason for the accused to kill her husband. Therefore, in our opinion, the present case would fall under the exception number 1 of the Section 300 IPC. The appellant, apparently a victim of circumstances and hence deserves a lesser sentence of 5 years imprisonment instead of rigorous imprisonment for life. Stop.